In the matter of SANDHIR versus Central Bureau of Investigation, Supreme Court held that we do not find fault with the impugned judgment of the Delhi High Court. However, the issue of whether the CDs produced were the same which were seized on 4th May 2013 and 10th May 2013 was left open. The issue regarding validity of certificate under Section 65B of Evidence Act was also left open. The issue of authenticity of CDs was kept open. The CDs were sought to be produced after recording of evidence of some of prosecution witnesses. Court said that it will be open for appellant to recall the prosecution witnesses for cross-examination on a limited aspect of the CDs. The factual aspects which emerged from this case can be summarized as under. The CDs were seized on 4th and 10th of May 2013. On 27th May 2013, the CDs were sent in a sealed envelope by respondent to the CFSL. On 2nd July 2013, when first charge sheet was filed, opinion or report of CFSL was not received. On 25th October 2013, report of CFSL was received. And on 30th October 2013, supplementary charge sheet was filed under Section 173(8) of the CRPC. The CFSL reports were filled with the charge sheet. Supplementary charge sheet refers to the seizure of CDs and the fact that specimen voices of the accused, including the appellant, were recorded and forwarded to CFSL along with the seized CDs in a sealed envelope. Along with the charge sheet, apart from original CFSL report and other documents, certificate under Section 65B of Indian Evidence Act 1872 was produced. Strong reliance was placed on decisions of the court in the cases of Siddharth Vasisht and V.K. Sasikala. The two decisions operate in completely different fields. Decisions were on the right of the accused to get the copies of all relied documents. Basically, these two decisions deal with Section 207 of CRPC, which deals with supply of a copy of police report and other documents to the accused. In the present case, question is whether the respondent CBI can be permitted to produce the CDs which were inadvertently not produced along with supplementary charge sheet. Even if the documents or things which were inadvertently not produced along with the charge sheet were allowed to be produced. The decisions in the cases of Siddharth Vasisht and V.K. Sasikala will have no application. In the facts of the case, the CDs were seized and referred for forensic analysis to the CFSL along with the voice samples of the accused. The CDs were referred to in the supplementary charge sheet. After report of CFSL was received, supplementary charge sheet was filed for placing on record the said report. Therefore, when CDs were sought to be produced, in a sense, they were not new articles. The CDs were not very much referred in the supplementary charge sheet filed on 13th October 2013. There was only an omission on the part of the respondent-CBI to produce the CDs. Therefore, applying the law laid down in the case of R.S.Pai, impugned judgments of Special Court and High Court cannot be faulted with. Court said we do not see how the decision in case of R.S.Pai requires consideration. Thus, in view of the Supreme Court, the High Court ought not to have gone into the issue of authenticity of the CDs allowed to be produced. Whether the CDs produced were the same which were seized on 4th May 2013 and 10th May 2013 is something that will have to be proved by the prosecution in the court. The issue regarding the legality of certificate under Section 65B of Evidence Act ought not to have been dealt with at this stage, said the court. Even if the production was allowed, issue of CD's authenticity remains open.